Thank you, Acting President. I rise to support this Youth Justice Bill 2024 as it will establish a robust end-to-end framework for Victoria's youth justice system and is all about improving our community safety. It's an important step in reforms to deliver what will be modern and effective responses to youth offending, and it is guided by evidence. Through these reforms, it aims to reduce offending and improve community safety, whilst providing genuine opportunities for young people who come into contact with youth justice to turn their lives around. This is about doing more of what works to keep the community safe. This bill contains nation-leading reforms which build on Victoria's success in driving down the numbers of young people engaged with youth justice. This is a result of a significant amount of work following the central recommendation of the 2017 Armitage and Ogloff Review that Victoria establish a new dedicated Youth Justice Act. This is about ensuring we have a modern and robust youth justice framework that is focused on community safety and guided by the evidence of what works. We know that children and young people who come into contact with the criminal justice system need a different response to adults, recognising their maturity and capacity for rehabilitation. The best way to do that is to divert young people away from the criminal justice system as early as possible, while holding serious and repeat offenders to account. There are also key reforms for victims of crime, including creating a new victims register for people impacted by youth offending. This is also about being tough on youth crime while also being fair on young kids. The bill will make Victoria the first state in Australia to raise the minimum age of criminal responsibility to 12 and includes an electronic monitoring trial for young people on bail. The bill is also a comprehensive reform across the full youth justice system. We're legislating making early pre-change diversionary opportunities, including warnings, cautions and early diversion group conferencing, supporting better outcomes for victims of crime. The bill includes clear principles for sentencing, custody and other important factors that must be taken into account when a young person comes into contact with the criminal justice system. We're legislating a new custodial framework to make our youth justice precincts safer for those in custody, and just as important, for our hard-working youth justice staff. And in addition to electronic monitoring, the bill includes other measures to respond to a small cohort of serious repeat offenders, with enhanced measures to target high-risk, high-harm offending. The bill also includes meaningful steps towards establishing a self-determined Aboriginal-controlled youth justice system in the future. Through this bill, Victoria will become the first state to raise the age of criminal responsibility from 10 to 12 years old. Changing one number in this legislation may seem small, but the message is significant. Our 10 and 11-year-olds do not belong in custody. They belong at school, with their families, carers and communities. We're doing this because this is the right thing to do, not just for the children involved, but because it's the best thing for the safety of our community. The evidence is clear that the younger a child is when they're first sentenced, the more likely they are to reoffend and reoffend more frequently, violently and as adults. Focusing on helping these children address the underlying causes of their offending and get them on the right path will keep the community safer in the long run. We know that serious offending by 10 to 11-year-olds is very rare, as is the situation where a 10 and 11-year-old would come before our courts, and rarer still that a child that young would receive a custodial sentence. We thankfully do not have any children in the system of this age, and with these important reforms, we never will again. In the rare situation in which a 10 or 11-year-old does engage in criminal activity, it stems from something going very wrong in their life. This warrants a response of help and support, one that is not best done through the criminal justice system, but instead through support services with age-appropriate services. The evidence tells us that this approach works. This is because very young children typically lack the maturity to form criminal intent, and their charges end up being withdrawn or not proven. If we don't focus on helping these children get on the right path now, we end up paying for it with our criminal justice system needing more resources into policing their behaviour as adults to keep the community safe. Raising the minimum age does not mean the child escapes consequences. It's entirely appropriate and expected that children will be held accountable for their behaviour, particularly where this leads to serious harm. What raising the age does is recognise that the criminal justice system as it stands is not the most appropriate way to hold a young child to account. Our education, child protection and youth justice systems have a number of programs and supports in place to support young people struggling with trauma, challenging behaviours and complex issues. This includes Victoria Police as frontline responders who have existing outreach and diversionary programs to engage informally with children without the need for criminal charges. The role of Victorian Police in protecting our communities cannot be understated, and we have engaged with VicPol closely in the development of this legislation, as police will still respond to protect community safety as they currently are able to with children below the age of criminal responsibility. As part of raising the age of criminal responsibility, the bill provides police with a specific set of additional powers for Victoria Police to transport children to a suitable person, such as a parent, or to an appropriate health or welfare agency where the 10 or 11-year-old child is determined to pose a serious risk to the safety of themselves or the community. Transporting might involve taking the child to another location, or it may involve police remaining with the child until a suitable person or agency arrives. If a suitable person or agency cannot be identified and there is continuing risk of serious harm, children can be taken into a police station where efforts will continue to locate a suitable person. This is what the public rightly expects and utilises a common sense approach to dealing with very young and vulnerable 10 and 11-year-olds in a way that ensures both theirs and the community's safety. These powers will operate alongside common law and statutory powers that might otherwise be available depending on the circumstances. For example, police will still be able to utilise breach of peace powers and powers under relevant mental health, control of weapons or drugs legislation. While the powers themselves are new, they are not about prolonging contact between police and the young people aged 10 and 11. These powers are intended to be a last resort option to give police the tools they need to keep the child and the community safe after the minimum age is raised. These will exist alongside operational strategies such as de-escalation techniques, such as asking the child to leave the place and go home. In situations that cannot be de-escalated and there continues to be a risk that a 10 or 11-year-old child will cause serious harm to themselves or another person, these new powers ensure police have the legislative coverage they need to respond to serious risk as a community would expect. In this situation, the child will be taken into the care and control of police until a suitable person can be located who can then take care of the child. A suitable person is a person who a police officer believes on reasonable grounds is capable of caring for the child and consents to take care of the child. The legislation provides examples of a parent, a relative or an adult known to the child and police are able to get the views of the child on who they see as the most appropriate person and can also speak with parents, relatives or service providers to help determine who the most suitable person is in the circumstances. Where the 10 or 11-year-old is Aboriginal, police must contact an Aboriginal organisation to help determine who is a suitable person, unless it is not reasonably practical in the circumstances. In situations where a suitable person cannot be located, the bill enables police to transport a child to a police station where the officer reasonably believes if the child was released from the station, the child's behaviour would be likely to cause a risk of serious harm to themselves or another person. Again, this is a power to enforce protection, not interrogation. Children taken to a police station cannot be held in a police cell and must not be questioned about possible offences committed by others. From there, police will continue to try and contact suitable persons or appropriate health or welfare agencies who can take care of the child. Alternatively, if a suitable person cannot be located and police consider there is no longer a risk of serious harm to the child, they will be required to release the child from their care and control. If police consider there are child protection concerns, they may take the necessary steps to make a report. There will be safeguards for the use of these powers, including training for police in the exercise of these powers, recognising the young age and vulnerabilities of this cohort of children to ensure that police practices are informed by an understanding of child-specific development factors and support culturally safe engagement. The bill also includes a robust monitoring and reporting framework for when these powers are used, including reporting to the Commission for Children and Young People, who will have new functions to monitor the exercise of the transport power and prepare annual reports for Parliament about the exercise of the power. This complements the existing oversight mechanisms that apply, including the role of IBAC in relation to police and Victoria Police's internal review processes. Raising the age of criminal responsibility must be done in a way that prevents the exploitation of young people in criminal activity. This is why the bill proposes to make a series of changes to the charging framework of recruitment offences involving young children. This includes amending the definition of criminal activity for the offence of recruiting a child to make it clear that this includes conduct by a child who is under the minimum age or is presumed incapable of committing an offence because of the Dolly Incopax principles. In practice, this means that those who recruit or incite a child under 14 to commit an offence, or even conspire to, will still constitute criminal activity for the purpose of prosecuting an adult charged with the recruitment offence. Add to this, we're also lowering the age of which offence for recruiting a child to offence applies, from 21 to 18. Together, these changes make blatantly clear that involving young children in offending schemes offers no protection and that there are clear and further reaching consequences for this conduct. While the bill raises the age of criminal responsibility to 12, the bill also codifies the existing common law doctrine of Dolly Incopax, or Dolly, for 12 and 13-year-olds. Dolly means is that a 12 or 13-year-old child can only be found to have criminal capacity if the prosecution can prove beyond reasonable doubt that the child knew their conduct was seriously wrong in a moral sense, as opposed to merely naughty or mischievous. This doctrine is a long-standing and fundamental common law principle that acknowledges that a child under the age of 14 lacks the mental capacity to form criminal intent by virtue of their age and relative development. This presumption exists in every jurisdiction in Australia and in other common law countries overseas. While this already exists in practice, stakeholders across the legal sector have fed back that Dolly is not well understood in the system and is often applied inconsistently. The bill seeks to remedy this by setting out a new procedural requirement for police officers when deciding whether to charge a child aged 12 or 13 years old when the alleged offence was committed. Specifically, police must have regard to whether it appears there is admissible evidence to rebut the Dolly presumption beyond reasonable doubt prior to commencing criminal proceedings against a 12 or a 13-year-old. Things police may consider when making the determination can include the child's age, maturity and stage of development, the history of offending, whether the child has any disability or mental illness, and any other matter relevant to making the determination of their criminal capacity, as well as evidence from witnesses about what the child may have said or done in the lead up to the offending. This then leads to more efficient outcomes for children so that those 12 or 13-year-old children who do not or are unlikely to have criminal capacity avoid unnecessary contact with the criminal justice system. It also means we avoid wasting police and court time on lengthy criminal proceedings that have no reasonable prospects of conviction. Nothing in the bill, including the new police requirement, limits a police officer's ability to arrest a 12 or 13-year-old child where they are permitted to do so by law. For example, if police believe on reasonable grounds a child has committed an indictable offence, such as an aggravated burglary or theft, police will also retain their discretion to charge 12 or 13-year-olds by arresting and charging on summons. It's important, however, that charges are only laid against a 12 or 13-year-old child where there is evidence and reasonable prospects of a conviction in some circumstances. This may mean it is inappropriate for police to charge a child after investigating and obtaining necessary evidence to support a charge, including evidence to rebut Dolly. This again builds on the overarching objective of this bill to ensure the system is more attuned and cognisant of responding to youth offending in a developmentally appropriate way for the children that it is dealing with. Victims are at the heart of the Youth Justice Bill, and this reform adopts a victim-inclusive approach. We know the profound effect that crime can have on victims. The Youth Justice Bill will ensure that the impact of victims is considered in all decisions and that victims have a voice Acting President, I'm out of time, so I'll leave my contribution there.
Thank you, Mr. McIntosh.